Okay, I need you to stop what you are doing and pay attention, because what happened in a federal courtroom at 4:47 yesterday afternoon just destroyed the last legal shield between Donald Trump and a prison cell. And here's the thing that is driving me absolutely insane. Nobody is talking about the actual document that did it. Not CNN, not MSNBC, not even the legal analysts who should know better. They are all focused on the headline. They are all repeating the same talking points. But they are missing the one single page buried in Judge Tanya Chutkan's ruling that changes absolutely everything. If you care about what happens next, subscribe to this channel right now. Hit that notification bell, because I am about to show you exactly what everyone else is ignoring and why it matters more than anything you have heard today. Here is what happened. Judge Chutkan issued a 6-page supplemental order yesterday, 6 pages. Most news coverage spent about 30 seconds on it before moving on to the next story. But I read the entire thing twice. And on page 4, paragraph 3, there is one sentence that just obliterated Donald Trump's immunity defense, not just in the January 6th case, but across all 4 criminal prosecutions he is facing right now. Let me read it to you directly. The defendant's conduct, viewed in totality, demonstrates a pattern of behavior inconsistent with any claim of official presidential action. Do you understand what that means? Judge Chutkan is not just ruling on one charge or one incident. She is establishing a legal framework that says Trump's entire pattern of behavior shows he was not acting as president. He was acting as Donald Trump, desperate candidate trying to hold on to power. And here is why this matters right now, today, this week. Prosecutors have 14 days from yesterday to file their official acts analysis. 14 days, that puts us at February 15th, 2026, exactly 3 weeks before Super Tuesday. Do the math. The trial could start before Republican voters even decide the nomination. If you think this does not matter, if you think Trump can delay his way out of this, stay with me, because what I am about to show you next is going to prove you wrong. Let me show you what prosecutors submitted to Judge Chutkan that nobody has reported on yet. 3 separate documents, 3 different evidence streams, and when you connect them, they do not just damage Trump's immunity claim, they annihilate it completely. Document number 1. The phone log. This is White House telecommunications data from January 6th, 2021, official records that the Secret Service maintained and that Jack Smith's team obtained through subpoena. And here is what it shows. Between 11:30 a.m. and 6:45 p.m. that day, Donald Trump placed 18 phone calls to Rudy Giuliani. 18. Now you might be thinking, okay, so what? The president can call whoever he wants, right? Here's the problem. Not one single call went through the White House switchboard. Not one. Every phone call a president makes in an official capacity gets logged through the official system. That is standard protocol. That is how we maintain records. That is how we ensure transparency. But Trump used his personal cell phone for every single one of those calls. Do you understand what that establishes? It proves Trump knew these conversations were not official government business. He was coordinating with his personal lawyer about campaign strategy. And when the President of the United States deliberately avoids creating a record of his calls, that tells you everything you need to know about whether those calls were official acts. They were not. Document number 2, the email chain. This came from inside the White House counsel's office. We are talking about Trump's own lawyers, the people whose job was to advise him on what he could and could not legally do. And on January 4th, 2021, 2 days before the Capitol attack, White House counsel Pat Cipollone sent a memo to Mark Meadows, Trump's chief of staff. The subject line read, quote, "pressuring the vice president regarding electoral count." And in that memo, Cipollone wrote explicitly that any attempt to pressure Vice President Pence to reject electoral votes would be, quote, legally problematic and not within the scope of presidential authority. Let me say that again. Trump's own White House lawyers told him directly that pressuring Pence was not within his authority as president. This destroys the advice of counsel defense. This destroys any claim that Trump thought he was acting within his constitutional powers. He was warned by his own legal team, and he did it anyway. That is not a president performing official duties. That is a candidate ignoring legal advice to pursue a personal political goal. Document number 3, campaign finance filing. Federal Election Commission records show that between December 15th, 2020 and January 31st, 2021, the Trump campaign paid $3.2 million to law firms involved in the fake electors scheme, $3.2 million. And here is what makes this so damaging. The payment started before January 6th. This was not a reaction to events. This was coordinated planning. And it was paid for with campaign funds, not government funds, campaign money, When you use campaign dollars, you are engaging in campaign activity. And campaign activity is not an official presidential act. It is personal. It is political. It gets zero immunity protection. Do you see what just happened here? Judge Chutkan did not just rule on one document. She connected 3 separate evidence streams, phone records proving Trump used personal devices to avoid creating official records, internal emails proving Trump was warned by his own lawyers that he was exceeding presidential authority, and campaign finance records proving Trump paid for the entire operation with campaign money, not government resources. Every single thread points to the same inescapable conclusion. Donald Trump was not acting as president of the United States. He was acting as Donald Trump, the candidate desperate to stay in power. But wait, because here is where it gets absolutely devastating. There is a 4th document, and this one Jack Smith has been holding back until exactly the right moment. Stay with me. Here's the thing that nobody is connecting yet. This ruling does not just affect the January 6th case in Washington. It creates a framework that collapses Trump's immunity defense across every single criminal prosecution he is facing. Think about it. The Georgia case, Trump calling Brad Raffensperger, the Georgia Secretary of State, demanding he find 11,780 votes. That was not a president performing official duties. That was a candidate trying to change election results in one specific state to benefit himself. No immunity. The classified documents case. Trump hiding boxes of national defense information at Mar-a-Lago, showing them to visitors, refusing to return them even after subpoena. That happened after he left office. He was a private citizen. Zero immunity. Not even a debate. The New York case. Hush money payments to adult film actress Stormy Daniels to influence the 2016 election. Personal conduct. Campaign-related. No connection to presidential duties whatsoever. No immunity. Do the math. Trump faces 91 criminal counts across 4 jurisdictions. Judge Chutkan's framework just removed immunity protection from approximately 87 of them, 87 out of 91. That is not a legal defense. That is a legal collapse. Now, let me show you the 4th document. Remember I told you Jack Smith was holding something back? Here it is. Secret Service logs from December 18th, 2020. These are not White House visitor logs that presidents can control. These are Secret Service protective detail records. They cannot be altered. They cannot be hidden. And they show that on December 18th, Donald Trump held a meeting in the Oval Office. Who attended? Sidney Powell, Michael Flynn, Rudy Giuliani. Do you know what those 3 people have in common? Not one of them held a government position. Powell was a private attorney pushing conspiracy theories about voting machines. Flynn was a private citizen who had been fired as national security advisor years earlier. Giuliani was Trump's personal lawyer. These were campaign advisors, political operatives. And Trump brought them into the Oval Office, the People's House, to strategize about overturning an election. Jack Smith obtained these logs because Secret Service has to comply with federal subpoenas. The White House could not bury them. And they prove beyond any dispute that Trump was using official government space for personal campaign activities. The Oval Office does not make something official. If you are using the People's House to plan campaign schemes, you are just a trespasser with a nicer address. Let me take you back to 1974 for a moment because this matters. Richard Nixon, facing impeachment for Watergate, had one final conversation recorded in the Oval Office, the smoking gun tape. And on that tape, Nixon discussed using campaign funds to pay off the Watergate burglars. It was recorded in the Oval Office. It involved the President of the United States. But when that tape became public, even Nixon's most loyal defenders in Congress abandoned him. Why? Because everyone understood that discussing criminal campaign activity in the Oval Office does not make it official. It just makes it a crime committed in a fancy room. Location does not determine immunity. Purpose does. If you are acting to benefit yourself politically, if you are coordinating with campaign operatives, if you are avoiding official channels and using personal phones, then you are not performing presidential duties. You are just a candidate abusing the office. Judge Chutkan just applied the exact same logic that destroyed Nixon, and Trump's lawyers have absolutely no answer for it. Now, let me break down exactly what happens next because the timeline is not theoretical anymore. It is locked in, and it is moving faster than anyone expected. February 15th, 2026. That is 14 days from Judge Chutkan's ruling yesterday. On that date, prosecutors must file their official acts analysis. That is the document where Jack Smith goes through every single charge and explains why Trump's conduct was personal or campaign-related, not official presidential action. We are talking about potentially a 100-page filing with evidence, witness testimony, documentary proof that hits the public record in 14 days. February 28th. Defense has 14 days to respond. Trump's lawyers have to counter every argument, every piece of evidence, every legal framework prosecutors establish. They are already scrambling because they know what is coming. March 7th, hearing before Judge Chutkan. Both sides present oral arguments. She asks questions. She probes weaknesses. This is where the immunity defense lives or dies in real time, on camera, in open court. March 14th. Judge Chutkan issues her final ruling on which charges proceed to trial. Based on her supplemental order yesterday, we already know how she is leaning. The immunity defense collapses. Most charges survive. April 1st, 2026. If the Speedy Trial Act is applied, if Judge Chutkan moves aggressively to protect Trump's right to a speedy trial and the public's right to justice, trial could start on this date. April 1st. That puts opening statements, witness testimony, evidence presentation before the Republican National Convention in July. This is not speculation. This is the mathematical reality of federal court calendars and statutory deadlines. We are looking at a 90-day window where everything, literally everything, could collapse for Donald Trump. Now, let me do the other math. The math nobody wants to talk about, but that matters enormously. Election interference charges carry a maximum of 20 years per count. Trump faces 4 counts. That is 80 years maximum. Obstruction of an official proceeding, 20 years maximum, 2 counts. That is 40 years. Conspiracy charges, 5 years each, 2 counts, another 10 years. Now, obviously, nobody serves the maximum on every count. Sentences typically run concurrently, not consecutively. But even a conservative estimate, even if a judge shows leniency, you are looking at 15 to 20 years as a realistic sentence if convicted on multiple counts. Donald Trump is 78 years old. A 15-year sentence is a life sentence. There is absolutely no getting around that math. If he is sentenced to 20 years at age 78, he does not walk out of federal prison. He would be 98 years old. The statistical probability of living to 98 while incarcerated is essentially 0. We are talking about a former president of the United States potentially dying in federal custody. That is not hyperbole. That is not partisan exaggeration. That is simply how the numbers work. And here's the political calculation that is terrifying Republicans behind closed doors. Recent polling shows 38% of Republican voters say they will not support Trump if he is convicted of a felony. 38%. In a general election, that makes him completely unelectable. You cannot win the presidency if you lose 40% of your own party. And here is the timeline problem. Super Tuesday is March 5th, 2026. That is when 16 states vote. That is when the Republican nomination could effectively be decided. And that happens potentially before Judge Chutkan's final ruling on March 14th. The Republican Party could nominate Donald Trump and then watch him get hit with a trial date and a conviction before the general election. Senate Republicans in swing states, Montana, Ohio, Pennsylvania, are already quietly distancing themselves. They see the polling. They know a convicted felon at the top of the ticket destroys their own reelection chances. The entire down ballot collapses. If this analysis is helping you understand what is actually happening, hit that like button right now. Share this video. Send it to anyone who thinks Trump is invincible. Because what I am about to tell you next is why his lawyers are genuinely panicking behind closed doors. Here is what we know from sources close to Trump's legal team. Last Friday night, his lawyers held an emergency meeting that lasted 4 hours. 4 hours. It started at 7 p.m. and did not end until after 11. And the topic was not legal strategy in the traditional sense. The topic was catastrophic scenario planning. That is the term one source used. Catastrophic scenario planning. They are not preparing for acquittal. They are preparing for conviction. And here is why. The witness problem. Mike Pence, Trump's own vice president, is cooperating with prosecutors. Mark Meadows, his chief of staff, has provided testimony. Pat Cipollone, his White House counsel, has given extensive interviews to Jack Smith's team. These are not peripheral figures. These are people who were in the room for every critical decision. They know what Trump said. They know what he was told. They know what he did anyway. The evidence problem. Phone records that cannot be disputed. Email chains that cannot be explained away. Secret Service logs that cannot be altered, campaign finance filings that are public record. Prosecutors are not relying on witness credibility. They are relying on documents, and documents do not change their story under cross-examination. The jury problem. This trial happens in Washington, D.C. In the 2020 election, Joe Biden received 92% of the vote in D.C., 92%. Trump's team knows they are not getting a jury sympathetic to their client. They need all 12 jurors to acquit. They need unanimity. and the statistical probability of finding 12 people in Washington who will ignore overwhelming evidence because of political loyalty is effectively zero. So what are the strategies? What is the actual plan? Strategy number one, appeal everything. But the D.C. Circuit Court of Appeals already rejected immunity once. Strategy number two, delay tactics. But Judge Chutkan has shown repeatedly she will not tolerate games. Strategy number three, political pressure on Republicans to delegitimize the trial. But Republican senators are quietly abandoning ship. Strategy number four, jury nullification, hoping one juror refuses to convict regardless of evidence. But that requires all 12, and it almost never works in federal court. Every single one of these strategies is desperate. Every single one is a Hail Mary. And desperation is what happens when you have run out of actual legal arguments. Trump's team knows they are drowning in evidence, and there is no lifeboat coming. But this is not just about Trump anymore. This is about whether we are actually a nation of laws or just a nation of powerful people who ignore laws when convenient. For 248 years, we have never had to answer that question for a former president. We are about to find out if the system holds. Here is what happens in the next 72 hours. Not next week, not eventually, this week. Monday morning, Trump's legal team will file an emergency appeal to the D.C. Circuit Court of Appeals. They will argue Judge Chutkan exceeded her authority. They will demand a stay of proceedings. That filing is expected before noon Eastern Time. Tuesday, prosecutors are expected to file a motion for an accelerated trial schedule. Jack Smith's team wants this case in front of a jury as quickly as possible. They will argue that Trump's Sixth Amendment right to a speedy trial actually requires moving fast, not slow. That motion hits the court record Tuesday afternoon. Wednesday, there is a genuine possibility Trump's lawyers file an emergency petition with the Supreme Court, asking the justices to intervene, to pause everything, to prevent Judge Chutkan from moving forward. These are not hypotheticals. These are scheduled calendar items happening this week. But here is the question we actually need to be asking. This is not about will Trump be convicted. That is the wrong frame. The question is, can the American justice system actually hold a former president accountable? Because if the answer is no, if wealth and power and political influence can simply override evidence and law, then everything we believe about equal justice under law is a lie. It is theater. It is pretend. But if the answer is yes, if the system can actually function the way it was designed, then we are about to witness something that has never happened in 248 years of American history. Subscribe to this channel right now if you have not already. Hit that notification bell because when prosecutors file that official acts analysis on February 15th, I will break it down line by line. You will see it here first. Like this video. The algorithm decides what reaches people. You can decide this reaches more people, share it, send it to someone who needs to understand the legal walls closing in, and drop a comment. Do you think Trump faces trial before the election, or does he delay past November? I genuinely want to know what you are thinking. I am staying on this story every single day. When Judge Chutkan rules, you will see it here first. When Trump's appeals fail, you will see it here first. When the trial date is set, you will see it here first. The legal bomb dropped yesterday. The explosion is still unfolding. Stay with this. I will see you in the next one.